Okay, good morning. I'm taking the floor after a very interesting discussion of particular issues of the European Union law. And as you can see, I will make a presentation on the right to property under Article 1 of Protocol number 1 to the European Convention of Human Rights and Article 17 of the Charter. But I will focus mostly on the European Convention for several reasons. First of all, because I work for the European Court of Human Rights and I have an expertise in its case law. And secondly, here my colleagues who are specialists in the European Court of Justice law can correct me. But when I did a research on Article 17 of the Charter, I didn't find that many cases where the European Court would refer to this provision in examining a particular tax issue. I think that mostly, as we saw in the previous presentation, these taxation cases concern other provisions of the Charter, for example, 16, the right to conduct business, and other ones. And Article 17, even though it has a similar scope of application as Article 1 of Protocol number 1, is not that often referred to. So before I go into the substance of my presentation, I need to make a disclaimer. As I'm a staff member of the European Court and of the Council of Europe, still the views presented in this, during this presentation are those of mine and do not represent the official position of the European Court or of the Council of Europe. So, Article 1 of Protocol number 1. I would like to place you in a broader context than the European law, because here we are talking about the European Convention. We are talking about 47 member states, which include not only European Union member countries, but also Eastern Europe, and this provision has a bit different scope of application. Now, to understand what underlines the European Court of Human Rights reasoning in particular tax issues, it is also important to remember a little bit of history of how this particular provision was drawn up. Because you know that the European Convention came in the aftermath of the Second World War. And when it comes to Article 1 of Protocol number 1, you do not find it in the main text of the Convention. Why? Because the states could not reach an agreement on that provision, because it limits the economic power of the state, it limits its discretion to implement economic policy. That is why the states that were the authors of the convention, they agreed to put it in a separate protocol, and as probably some of you know, there are countries that are members of the convention, but did not ratify Article 1 of Protocol number 1, for example, Switzerland or Monaco. So you cannot bring a tax case against Monaco under Article 1 of Protocol number 1. And when it comes to Switzerland, for example, we also see some very interesting case law under Article 8 or under other articles, but it is not possible to complain under Article 1 of Protocol number 1. So as a result of this agreement, Article 1 guarantees not absolute but limited ownership, as well as Article 17 of the Charter. It means that the state has the right to design and implement tax policy, and it has a wide margin of appreciation in the matters of economic policy. Now, the European Court of Human Rights repeats it in every single tax case. You can find it in any decision or any judgment concerning a tax case under Article 1. This reference to the state's power to implement economic policy, because, of course, the national authorities, they better know which taxes to impose and to levy and how to better design its own tax policy. That's why the European Court will not go deep into the particular issues of taxation, but it will look at whether the taxpayer had guarantees against arbitrariness. So here, in a way, we have two issues at stake. on the one hand, we have a state prerogative in tax matters. On the other hand, we have guarantees for taxpayers, and the court will examine in each particular case whether the taxpayer had these guarantees and whether the margin of appreciation was respected or not by the state. So I will focus on 6 particular issues which I identified in the case law under Article 1. I will talk about VAT cases. I will talk about lawfulness of interference, which is quality of fiscal laws, individual and excessive burden, retroactive legislation, austerity measures, and procedural safeguards. And by the way, yes, you have the text of the presentation with reference to the cases, so you can find it in your materials. Now, when it comes to VAT cases, those of you who specialize in these matters probably know 2 most famous cases, which is Intersplav versus Ukraine and Bulves AD versus Bulgaria. Now, these are classic VAT cases where the court found a violation of Article 1 of Protocol number 1. It was 2007, 2009, but since then we see a slight departure in the case law in finding no violation or declaring the complaints inadmissible. Now, the first issue that arises when we talk about VAT cases is the issue of possessions. Now, when the European Court of Human Rights examines a case under Article 1, there is a particular test, proportionality test, which is common to other articles of the Convention, like Article 8, for example, Article 10, 11, and so on. But under Article 1, the first question that arises for the court is, did the applicant have a possession? Now, of course, when we're talking about existing possessions, like, for example, when the land was expropriated and a taxpayer was imposed a tax on the compensation amount, this is an existing possession, clearly. But when we are talking about VAT cases, there is a question of a legitimate expectation. And the question of legitimate expectation is a complex one because the court has to look at whether, under the domestic law, a taxpayer had an appropriatory interest recognized by this national legal provision. And even though the court does not review the domestic court's findings, in this issue it will have to look at them in order to understand whether the interpretation by the domestic court of this particular issue gave the applicant an entitlement, gave him this legitimate expectation that he or she or it will obtain some property in the future. Now, we have 2 kinds of a legitimate expectation. First one was introduced in Bulves AD. This is a right to claim a deduction of input VAT, which was paid to supplier. Common system, I think it's quite common not only to European Union, but to other Eastern countries as well. In Bulves, the situation was that the applicant company purchased goods from another company. Of course, it recorded the purchase in its accounting records and filed the VAT return, which was paid to the supplier in August. The supplier had his own VAT reporting obligations, but the supplier did not enter this VAT for this period, entered it for October, and subsequently reported it for a later period. So when the tax authorities were conducted an audit, they refused Bulves in deduction of input VAT because the periods didn't coincide. They were different. And when the court looked at the facts of the case, it found that Bulves, the applicant company, it complied fully with its VAT reporting obligations. There was no fraud on the part of the applicant company. But the supplier did not comply with the reporting obligations. The applicant company had no possibility of somehow controlling the supplier. You can do nothing if your supplier does not report the VAT in a proper time. So what happened was that the state budget received the VAT twice because Bulvis was refused the right to deduct and had to pay. And the court said that in this case, the applicant company had a legitimate expectation to be allowed to deduct the input VAT because it complied with its reporting obligations and it could not control the supplier. A similar approach was taken in another Bulgarian case, but which ended in a decision. It was Artiv versus Bulgaria, where also the applicant purchased some goods from a supplier, paid a VAT, but when it came to deduction, it was found that the supplier did not enter VAT in its accounting records at all. And then subsequently the documents were lost and the state could not verify whether the supplier did in fact pay VAT to the budget or it did not. So still in that case, the court said that the applicant had a legitimate expectation because it complied with its own reporting obligations. The second issue is a right to obtain a VAT refund, and this is the case of Intersplav versus Ukraine, where the applicant, VAT refund, this is the case when the goods are exported at a zero tax rate, and then the applicant company can have a VAT refund on, for example, the goods or services purchased within the country. So the Intersplav, Ukrainian-Spanish company, it had the right to a refund, but the tax administration, the local tax administration, refused to issue a tax certificate, though they did recognize that the applicant company was entitled to it. And after certain delays, finally, they complained to the European Court. And the court said that under the national law, the applicant company had fully complied with the requirements to obtain this refund. But there was a recent case in the end of 2017. It was a quite complex name. It's Khabarovskaya Toplivnaya Kompania versus Russia, where the court also had to assess whether the applicant company had a legitimate expectation to obtain a VAT refund. And in that case, the court went further. It reviewed the domestic court's findings of whether the applicant company had a legitimate expectation of obtaining this refund. So that's a rare case that the court goes so deep into reviewing the domestic court's findings, but it did in this case. And it found that the applicant company had not satisfied the necessary conditions to benefit from refund, and that was the reality of transactions with the suppliers. So the domestic courts, they found that the transactions were not real, so this requirement was not satisfied. Secondly, the suppliers' invoices, they contained false addresses and some unclear information about managers of those companies. And finally, the suppliers also failed to comply with their VAT reporting obligations. And the European Court considered that the domestic court's reasoning in that case was not arbitrary or manifestly unreasonable, and it said that the company, because it did not satisfy the domestic law requirements, it did not have a legitimate expectation to obtain a VAT refund in that case. So the case was declared inadmissible, which shows that in finding this first element, so the court didn't go further to the test, it stopped here. It shows that when it comes to a legitimate expectation, the recent case law shows that the European Court will review how the domestic courts examine this compliance of a taxpayer with the domestic law provisions. Now, the second issue under when it comes to VAT cases is the proportionality issue. Now, if we go again to the Bulves case, 3 criteria was introduced by the court, which was followed in further cases. First criteria was whether the applicant company discharged its VAT reporting obligations, which it did in the Bulves case. Second criteria was whether the applicant company could control or secure compliance with the reporting obligations by its supplier. In the case of Bulves, it had no control and it could not do so. And third criteria is whether the applicant company had a knowledge of fraud in that system or could reasonably obtain such knowledge. In Bulves' case, it had no knowledge and it could not obtain such knowledge, so all 3 criteria were satisfied, and in Bulves it was a violation. But in the other Bulgarian case, which I mentioned, in Ativ versus Bulgaria, the case was declared inadmissible. And personally, I don't agree with it because, as I told you the facts, the supplier did not report that and it lost the documents. What the court said? The court said, well, first of all, yes, the applicant, Mr. Ativ, he did discharge his obligations. Could he secure compliance by supplier? No, he could not. But even though the Bulgarian courts also followed the same rigid approach as in Bulves, in this case, the court said that this approach was acceptable. It was acceptable, as it seems, for one reason, because in Ativ case, the VAT was not paid to the state budget. So the tax authorities could, because the documents were lost, the tax authorities could not verify whether it was paid or not. They presumed it was not. In Bulves' case, it was paid twice, so there was no disadvantage for the budget. So you see, the main reason for the European Court is the financial one in the end. And personally, I think that in Ativ, of course, the applicant was put in a disadvantaged position by this decision, because if you comply fully with your reporting obligations as a taxpayer, how can you ensure that your supplier, which is a real company that exists, it's not a false one, there is no fraud, like from the first side, how can how could the applicant ensure that the supplier pays VAT and reports properly its obligations? Well, the court had one sentence in the reasoning. It said that, well, finally, the applicant could bring a claim in the domestic proceedings against the supplier seeking compensation. No, but it's a rather vague assumption here, because no one knows how the domestic proceedings would end. Okay, I will not focus much on the third VAT issue, which is the abuse of system, because here it's obvious that there is a need to curb any attempts to abuse the VAT system. There is a special diligence required of VAT-registered persons. In particular, this was underlined by the court in Nazarev and others versus Bulgaria case. The court also will look at how the contract in the member state applied particular measures in a particular case. For example, just a general information that, you know, an abuse of VAT system is being conducted is not enough to penalize somehow the applicant for this abuse. There have to be particular facts of involvement of a particular entity or a particular individual in a fraud or another abuse. And if there is a particular fact, then there can be a refusal of the right to refund or deduction, and it can be found to be justified under the convention. So I will now turn to the second issue, which arises under Article 1 of Protocol number 1, which is the quality of tax laws or fiscal laws. And here the court looks at the second element of the test under Article 1, which is the lawfulness test. So any measure, any tax measure has to be lawful, which means it has to have basis in the domestic law. But the concept of law under the European Convention has an autonomous meaning, which means, first of all, that it comprises not only statutory law, not only laws that are passed by the legislature, but also the case law. If it is a clear and consistent case law of the country, it will be taken into the concept of the law. Secondly, it concerns not only laws, again, taken by the legislature, but also decrees and rulings issued by the executive authorities. And thirdly, it's not only procedural tax legislation, but also substantive tax legislation, like laws imposing certain taxes and laying down certain rules, etc. So when we are talking about law, just the mere existence of a legal basis is not enough. The law has to be of a certain quality. And there are three requirements under the European Convention, which is the law has to be accessible, precise, and foreseeable. Now, when we look at the issue of accessibility, it means that a particular legal provision must be accessible to the general public. This issue was examined, for example, in the case of Spacek versus the Czech Republic. The facts of the case are a bit ancient, concern late 1990s. The applicant company was required to pay additional income tax because it didn't comply with the new rules issued by the Ministry of Finance. So the Ministry of Finance issued the rules and regulations that changed from single to double entry bookkeeping. Now, these rules, the important is that these rules and regulations were not published in the official gazette, which is the official source of information for legal practitioners, but it was published in some financial bulletin. So the applicant company presumed that it was not obliged to follow these rules because they had no official publication. And later they were obliged to pay the income tax because the rules have changed and an additional tax was calculated. So the applicant company complained to the European Court that the law was not accessible to it because it was not published in the official gazette. And the court made two very important findings in that case. First of all, it said that under the umbrella of the European Convention, there are no particular requirements as to the degree of publicity. In other terms, it is not for the European Court to tell the states how to publish particular rules. And the second one was that the applicant company, being a legal entity, could and should have sought an advice of professionals. And this second finding was, in a way, developed in, not in taxation cases, but in other cases concerning economic activities of private entities. So if we're talking about a citizen, this would not apply, but if we're talking about a legal entity, a company, it has the means and it should seek the advice of specialists of whether it has to comply with the certain provisions or, or not, or whatever. This was very important. This is a landmark case where these two findings were made, and it was applied in other cases. Now, second issue is that a law has to be precise. Well, of course, absolute precision, especially in tax law matters, is impossible. It is impossible to regulate in details every particular tax issue that might arise. So the court accepts that the domestic law is inevitably couched in general terms, but it is for the domestic courts to interpret these general provisions, and what the court will do, it will look in each and particular case how the domestic courts interpreted, whether they were substantiated, these decisions, or there was some kind of arbitrariness in this interpretation. So, for example, in the case of Masa Invest Group versus Ukraine, the court looked at the domestic court's finding, imposing a 20% VAT rate on the applicant company, and it considered that the domestic decisions were properly substantiated. On the contrary, in the Russian case of Khodorkovsky and Lebedev, and probably you've heard that Mr. Khodorkovsky was the former manager of the UCAS company, which I will talk later about that case as well. And he was UCAS company was brought to tax liability. It was imposed a big fine for its failure to pay taxes to the state. But also Mr. Khodorkovsky, as the manager, executive of the company, was also in the criminal proceedings obliged to pay to the state compensation, which was not, it had no basis neither in domestic law nor in the case law, in the Russian case law of the domestic courts. And the court said, when the court looked at the case, it said, well, there is no legal basis. Neither statutory law nor case law provides for that. So in that case, this was found to be unlawful. The third issue is the issue of foreseeability. Basically, it means that the taxpayer, from the legal provision it has, should foresee the consequences of his or her conduct in a particular case. Or in other words, there should be a measure of protection against arbitrary interferences by tax authorities in every case. And the UCAS case is where the issue of foreseeability was clearly breached. I will try to briefly explain the facts, but which are of course very complex. So the UCAS company in 2004 was brought to tax responsibility for its failure to pay taxes in the period from 2000 until 2003. The tax audit was conducted in 2004. The tax law in force then said that the company, there was a limitation period, which was 3 years. So basically what the tax authorities had no right to penalize it for the period of 2000 until 2001, because the limitation period had already passed by the time of tax audit. So what the commercial court, which was examining the case, asked the constitutional court to deliver an opinion. And the constitutional court in 2005 pronounces a judgment and says that if a taxpayer acted in bad faith during the cross-checks, etc., in inspection, then the limitation period can be extended. So you see, events of 2000, in 2005, we have a decision which says, well, you can be penalized because you acted in bad faith, and therefore the limitation period can apply. The European Court said that, of course, 5 years ago, the taxpayer could not preview such a change in the opinion of the Constitutional Court because no case law before that decision did really say that this could happen. So clearly, the taxpayer could not adapt its conduct to this new opinion. Of course, this is a quite rare case, and we can speculate why it was done in the UCAS case, but it's not the issue. Still, it can happen. It can happen, and if such cases arise, there is a clear breach. There can be a clear breach of foreseeability issue in it. Now, individual and excessive burden. The next issue under Article 1 of Protocol number 1. This issue is examined under the next element of the proportionality or of the test, which is also proportionality. The court looks at whether, in the particular circumstances of the case, the financial situation of a taxpayer was sufficiently is very important here, was sufficiently undermined. it's very difficult to draw general conclusions here because we have to look at the particular circumstances of the case, but I can give you just a few examples. For example, the mere fact that it is a high tax rate does not give a rise to a violation and does not mean that there was an excessive burden. A good example is the case of Imbert de Trémiol versus France, where the applicants complained that their assets were subject to 85% wealth tax provided by the General Tax Code of France. So 85% is quite a lot. But when the court looked at the particular legislation, it found that this tax was applied only to those applicants whose assets have exceeded certain value, so these were clearly not the disadvantaged group of population. Secondly, the purpose of the tax was that it was a solidarity tax, so it was aimed to serve public interest by financing the minimum welfare benefit. And thirdly, as the declarations of the taxpayers showed, their financial situation was not undermined, but their assets were growing. So the court said, in general, again, the complaint is manifestly ill-founded, and it declared it inadmissible. On the contrary, the two Hungarian cases that have already been referred to, which was NKM versus Hungary and RSZ versus Hungary, which concerned the severance pay. So in one case, there was a 98% tax on the severance pay in part that exceeded 11,900 euros. And in another case, it was a 52% tax. And in particular, when finding a violation, the court said that both applicants were subjected to excessive individual burden because also they were in a situation when they suffered a substantial deprivation of income because both applicants were dismissed from their positions, some on agreements, some not, but again, they had no other source of income. So you see, in these circumstances, there is a burden, unlike in Imbert de Trémiol, which I told before. And recently, there was a decision in an Italian case. It's a Cacciato and Guiso and Consiglio versus Italy, where the applicant had to pay a 20% tax on the compensation for the expropriation of land. Well, 20% is not was not found to be very excessive in that case, and the court also said that the applicants had not suffered any individual hardships in that case. And also, the individual burden can be imposed in other forms. It may not only concern the financial situation, but for example, in the case of Joubert versus France, the court also considered that the company was imposed this burden because it was impossible to challenge the tax authorities' decisions under the tax law provisions at a certain time. So basically, the applicant company was deprived of a possibility to obtain a reimbursement because it just could not bring the claim under the tax provisions. Next issue under Article 1 of Protocol number 1 is a retroactive legislation. This issue was raised already in the discussion, and quite often it comes also under Article 1 of Protocol number 1. Now, the court has quite an extensive and old case law where the issue of retroactivity has come into play. One of the first cases were National and Provincial Building Society, etc., versus the United Kingdom, quite a known case. And later, also a number of cases, because the states do have recourse to retroactive tax legislation in some cases. What the court said is that retroactive legislation is not prohibited under Article 1 of Protocol number 1. But what is important, there must be specific and compelling reasons, first, and secondly, impact on the individual financial position of the taxpayer in a particular case. So these are two criteria that the court will look at when it looks at the complaint about retroactivity of a certain legal provision. For example, there was a very interesting also French case, Arnaud and others versus France, where in fact two countries were involved, France and Monaco, but as far as you remember, Monaco did not ratify Article 1 of Protocol number 1, so its citizens could not bring the case. The applicants were 8 French nationals who live in Monaco. Now, those French residents who changed their residence in 1989 were not obliged to pay the wealth tax in France. What France and Monaco did in that case, in 2000, they came to a mutual agreement that they will apply the wealth tax to those residents who moved from France to Monaco with the aim of avoiding payment of this tax. So they decided that those taxpayers who moved since 1st January 1989 would be liable to pay this wealth tax since from 1st January 2002. Of course, this is the issue of retroactivity when the law is applied almost 13 years back. But what the French authorities in particular did, they sent all applicants ministerial letters notifying them of this forthcoming enactment of this law and also of its retrospective effect. They also invited the applicants to start paying the wealth tax, starting from 2002, though there was not yet an obligation. The law was enacted in France only since 2005, but already in 2001 and 2002, the French authorities were informing and inviting to pay. So, in the court, the applicants alleged that their right to property was breached because of the retroactivity of this measure. And the court examined it and said, well, there were specific reasons, which is the tax avoidance by French nationals who decided to move to Monaco in order not to pay this wealth tax, because in Monaco they did not. And secondly, there was no impact on their financial position because the authorities were diligent, they informed them in advance, they invited them to start paying even before the law was enacted. So they sort of made this transitory period for the applicants. And the court again declared the application inadmissible.
Sorry.
Yes?
So on the facts, so essentially the French people emigrated the second point in time.
To Monaco, yes.
Yeah. Then it comes the law, right?
Yes.
But the law says that you are going to provide, so you have to pay the tax from the moment the law comes into place. So the question was,
yes,
was whether there was a sort of an expectation that this provision, taxing also for people who are expatriated, would not come into force, essentially. So
they invited them. Yes, the law came into force only in 2005 for France. But already starting from 2002, the government started sending letters saying that the law will be enacted and inviting them to start paying.
So to start paying from 2001 or for 2002?
From 2002. From 2002. Although there was no yet a legal obligation, there was no law.
So
but they already started.
Okay. So
yes.
essentially France in 2005 wanted to tax something that should have been paid in 2002 on the excuse that there was this letter to say, look, we're going to...
You can interpret it in that way. And the court accepted it as a diligence on the part of tax authorities. But again, we come here to the margin of appreciation, and again, the court was saying that it is for the states to decide how to apply retroactively the law, and the aim was also obvious because I think, well, French lawyers, I think, definitely know the situation because there was a number of French residents migrating to Monaco with the aim of avoiding this wealth tax. Not only to Monaco, you know this. To Belgium, yeah, and also maybe you've heard this famous actor Gérard Depardieu who moved to Russia not to pay tax, Oh well, that's how it was explained, but he's what? Sorry.
He is a Belgian.
He's a Belgian resident. Okay, so I didn't know the details, but yeah. Well, you see, yeah, taxpayers try to avoid avoid taxation in these cases. And there were also two Italian cases by one applicant, in fact, Di Belmonte versus Italy, where also the issue of retroactivity came into play, because the applicant had a piece of land expropriated, but there was a delay on the part of the authorities to pay him compensation. And in the first case, there was a final court decision awarding him compensation. 7 months later, there is a law enacted, it comes into force, which makes this kind of income taxable, and the retroactivity is applied to the applicant, even though the final court decision awarding him compensation was taken 7 months before coming into force. And the court found a violation here. But in another Di Belmonte case, there was another period, 20 days, 7 months, and here 20 days, and the court said that 20 days were not unreasonable here for the retroactivity reasons, and that application was declared inadmissible. So here what was important for the court is the period which was given to the applicant for sort of adjusting, no, not adjusting, but period between the enactment and the arising of the tax. Now I will go quickly to the austerity measures. There was a recent case quite widely discussed, Plaisier BV versus the Netherlands, and I think maybe later some of my colleagues will discuss it. This was a case against the Netherlands, where we had 3 applicants, 2 financial holding companies, and a Rotterdam football club. And what happened in the case was that the Netherlands, in the context of the financial crisis, which we are all well aware of it, and different measures have been taken both in the contracting states and the European Union to combat it. So, and what the Netherlands did in 2013, if I'm not mistaken, they levied high wages tax surcharge on certain employers, in particular those employers who were paying wages in excess of 150,000 euros. So the wages in excess of this amount were subjected to higher taxes. So the applicants were these employers who had to pay these taxes. And in these applications were declared inadmissible, and the court looked at the context of the austerity measures and of the financial crisis in general. There is a very good recap of the court's case law on the austerity measures in this decision, and also of the European Union measures that were taken in general. And what the court said, that in these cases, the states enjoy even wider margin of appreciation than ever under Article 1 of Protocol number 1. The court said that when there are limited budget resources, it is for the states to find the best solution, how to combat the crisis, and how, also in the context of the European Union, how to take measures which would be compatible with this general politics, economic policy of combating the financial crisis. So in this case, the court considered that, well, this was not disproportionate, because also, again, in the facts of the case, there was a certain amount of wages that was subjected to taxation, and it was not the very disadvantaged group of taxpayers. So finally, briefly about the procedural safeguards. My colleagues will later speak about Article 6 of the European Convention, but the ordinary tax disputes which do not involve criminal charge do not come under the scope of this provision. However, Article 1 of Protocol number 1, and this is quite often forgotten about, but it has a procedural aspect, because the court will look in the cases whether the applicant could, or the taxpayer, could argue his case in the domestic courts. It means that he could bring the claim, he or she or it could bring the claim, enjoyed the benefit of adversarial proceedings, and had its case examined by the domestic courts. This will influence the proportionality finding by the European Court if in general there was a protection of a taxpayer against arbitrariness. And I gave you a few examples where the European Court said, for example, here, yes, the applicant had the benefit of adversarial proceedings, and it was taken into account. And the other cases, the applicant could not challenge the tax measure taken against the taxpayer. So, of course, when the taxpayer cannot challenge the measure at all, this is a problem. It can also be not only a problem under Article 1, but under Article 13 of the Convention, which guarantees the right to an effective domestic remedy. But here the court will also take this into account. So I will finish here. Thank you very much for your attention. And if you have any questions, you can start the discussion. Thank you.